The arms deal trial involving former President Jacob Zuma and French arms company Thales is back in the Pietermaritzburg High Court this morning. It was postponed pending a new appeal to have State Prosecutor Billy Downer removed. Judge Piet Koen dismissed Zuma's bid for leave to appeal his judgment. The Supreme Court of Appeal later upheld Koen's decision, but Zuma's legal team filed for a reconsideration application. Joining me now is legal analyst Benedict Phiri to unpack the implications. Benedict, good morning. Let's start with the implications, or rather the reconsideration application. What is that reconsideration application?
Yeah, so in accordance with the Supreme Court rules, a litigant has the ability to approach the President of the Supreme Court to reconsider any outcome that has been given within that Supreme Court of Appeal. So we know that the Supreme Court of Appeal refused Jacob Zuma's application for leave to appeal Piet Koen's judgment, which confirmed that there was no prospects of success for him on appeal. And what the President of the Supreme Court will really be looking at here is to assess whether there are factors in this application which go further than just a reasonable prospect of success on appeal. And the type of factors we're looking at here is that she has to be convinced that there would be a manifest denial of justice, and I'm using the words that have been used in previous court cases, that there's a manifest denial of justice should this leave to appeal not be granted, and that the actual question of title to prosecute is of such immense public importance and importance to the parties. So, on those two aspects, I think in as much as we can't prejudge what the President of the Supreme Court of Appeal will think on the matter, I think it will be difficult for Jacob Zuma to even be successful in the reconsideration, because I think we've read the judgment of Piet Koen and we understand the reasons why this question can still be determined at a different stage of the trial for the President, and may not result in a manifest denial of justice if the leave to appeal is granted at this particular point in time.
So if it seems so apparent to you, and certainly to many other analysts, what do we read into the fact that while Tuesday was set as a holding date, the Supreme Court of Appeal, Judge Mandisa Maya, has not yet come back with a decision on that?
I don't think we can read much into that. Judges and the courts work in their own special way. We don't know what the caseload is in front of the President or what other matters she's considering. We actually really don't know what the work of the Supreme Court is at this particular point in time. So we just know that we wait for decisions when they come. And when they do come, fortunately, in a vast majority of the circumstances, if not all of them, they set out the reasons and the grounds for that decision. And to the extent that there may be any errors, those may then be appealed if there are appealable errors. But certainly I don't think we can read much by the fact that it's still sitting on the President of the Supreme Court of Appeal's desk.
Benedict, it's almost certain that there will be a postponement this morning. What sort of timelines can we expect from Judge Mandisa Maya to get back to the courts on that decision?
Again, that's very, very difficult to assess, right? Just given we don't know how long it will take for her to write whatever decision she writes, or what she's considering, the sources of law that she's considering to go into that decision, and how she's applying her mind in that. So we just don't know. But what I do expect to happen this morning is that, as you say, we will get a postponement to probably another holding date. We have seen that Piet Koen really wants to keep a handle on this matter to avoid further unnecessary delays and have the trial running as soon as possible from the time that we receive an outcome from the Supreme Court of Appeal, assuming that it won't be favorable to the former President.